There is more complexity in legal issues. As a result, we see many people, lawmakers and judges, that we have much more in cases of first impression and the effect that it has on authority. This brings back memories of a New Yorker cartoon from the 1970s where a group of lawyers in three-piece suits and smoking are in a law library scouring over all the legal books, with a partner standing at the end of the table with hands on hips, yelling, "I know the answer has to be in here somewhere," staring us in the face. This is the assumption that we traditionally had in the legal industry. You just had to find the law. It existed. You didn't have to make it up. Once you found that precedent, you could then advocate those precedents for your client. The assumptions may have changed now. This seems to have had an impact on what we now think about as precedents and authority. It goes to the idea of first impression. Law today is much more data-driven as more of the disputes center around finance and science. And it is much more fact-focused. Legal research used to be more rooted in theory or legal concepts, where we found the concepts and then placed the facts within that theory or concept. Today we look much more at the facts and try to pinpoint the law to that exact fact pattern. Much of the tools we have these days very much foster a fact-based inquiry and process. As a result of finding and following facts, we tend to rely less upon scholarly pursuits and output. And so less people read or follow law reviews, treatises or scholarly articles than they have in the past. Mainly because they don't fit the bill of the exact fact-based pattern and are therefore irrelevant to the process of research today. There are many more pro se professionals. They are wanting the information to be given to them directly. They do not want intermediation. This type of disintermediation is not only disruptive to the law librarian community, whose value has been placing themselves at that point of intermediation between the end users and the legal information. This is also a huge concern for practicing lawyers today. In many ways, their clients see them as the intermediary, and the clients now want to have access to the information directly. Clients are saying, "Let that information go to me directly." In law firms, there is a radical change in the business model due to these pressures of the pro se profession. Now let's sling an arrow at legal education. Legal education today is becoming more and more irrelevant. Legal education today is being taught by editor and isolation. You can go through 3 years of law school and never read a complete case. You learn through a case book that presents highly elicited cases to you. So you never have to go through the critical process of pulling out key points because the editor of the case book has done that for you. You have been spoon-fed the point that they are wanting you to learn. The same is true for statutory or regulatory courses that are studied primarily through cases rather than the actual laws or regs. You may take a tax law class and be asked to purchase the code book, but you are never asked to read it cover to cover. That might have been the best way to learn the subject and understand why you were sitting in a classroom learning this topic involving a statutorily based subject matter. Is it surprising that the McCrate report determined that there is a substantial disconnect between legal education and the practice of law? Law schools still insist that even in a transdisciplinary world, on teaching law in silos. Law is taught in subjects, and one facility member teaches without regard to what is being taught in another course. For years there has been talk of torts being the death of contracts, but hybrid courses on this very issue are not taught, where law students are taught to understand what that means and how those multiple disciplines fuse within the Anglo-American legal system. Legal education needs to change. Let's now discuss legal research and publishing trends. It was sad that the legal research profession lost Morris Cohen, but it is sadder that something Morris Cohen stated over 40 years ago has still not come to fruition. In Cohen's 1969 article for Jurometrics called Research Habits for Lawyers, where he stated, "We know a great deal about the materials of legal research, but almost nothing about the actual procedures used by lawyers in their search into the law." That challenge still exists. We all know about usability studies and how if you're over 35 your eyes go to the top left of the screen and if you're under 35 it goes to the center of a website. We also know about the psychology of color. Those are the easy things. That is the superficial intelligence. But what about the deeper intelligence of really understanding of how a lawyer or legal researcher makes a decision to accept or reject something in their argument? Do we understand the intellectual process that is actually going on? What are the ambiguous reasoning going on? The kind of things that the Watson computers of the world cannot do. That takes place during legal research. Our legal information professionals, publishers, librarians, judges, lawyers, law professors, how are we looking at that? What are we doing to address these kinds of processes? It is becoming more important today because the concept of the Holy Grail of authority has changed. So, what is authority? Traditionally, authority was based upon the idea of frequency. A.A.L.L. Hart called this the rule of recognition. Authority was also based upon maturity, the longevity of treatises or other legal writings. Authority in law has also been based on currentness. And most importantly, authority has been based on hierarchy. Certain judicial opinions are looked upon as being higher than others because it is part of our actual legal structure. In the new paradigm, authority is now taking into consideration the idea of availability. If you find it, is it authority? This takes the Dick Danner argument into account because Danner looks at the issue of availability as the great delusion of the value of authority. So, does the more followers you have on Twitter make you more of an authority? Is authority also based upon consensus? If we find enough people to agree with us, do we gain authority based upon that consensus? So there is a huge sea change on how people view authority. From maturity, currentness and hierarchy, to availability and consensus. What happens in this environment is that the walls of authority are a lot more porous and a lot more comes in and a lot more goes out. More going out than we would have let out in the past, more going in that we would not have included before. Add to that the idea that these walls of authority are also less structured. Think about the now old cartoon of two dogs at a computer saying, on the internet, no one knows you're a dog. It matters less about what authoritative platform you are standing, because you now have a forum for sharing your ideas. And the recipient that is getting those 174 plus equivalents of newspapers every day is not filtering or deciphering the podium from which you are coming, but they have easy access to what you are saying. We also have a tension within the law that pulls us back because we have an enduring inherence for print materials. The legal market acknowledges that most things are now born digital, but there seems to be a disconnect between what stays digital versus what is transferred over to print only, versus what is in both print and digital formats. We think that the amount of information within the U.S. government that is born digital and stays digital is only about 30% of legal information. This is a very low percentage when compared to the sciences, which is at 93% of information that is born digital and stays digital. Even the humanities is now at 76%. We still cling to print within law, and that has to do with 3 reasons. 2 of which are valid, and 1 that may not be a valid reason. Reason 1. The preservation aspect. We only trust print as our preservation medium. Until such time as technology can catch up on the issues of preservation, we have a concern that if it is not in a stable format, how will we know it will be there in 10, 20 or 100 years? Reason 2. The proof aspect. Many of our courts still say that they will only accept paper as proof. We do not want to take a risk of having something that we may have to prove the existence of and only having it in the born digital, stay digital format. Reason 3. We still cling to the idea of law being a learned and ancient profession. Print gives us a false sense of prestige and it makes us look more scholarly. Although this may be leaving us, it is still with us at the present time. In the next video we will discuss the changing roles of the players within our space,